consider when buying land for development purposes. Sarah's part of the session will be on the process relating to the sale of new build plots, and she'll also be doing a brief overview of the registration process. So I'm going to kick it off. Sarah, if you could just get the first slide up. Brilliant. Okay, so the first slide, as you can see, at what point is land purchased? So generally speaking, land can be acquired at various stages, and obviously depending on the type of deal, there are various structure setups. However, for the session today, as it is sort of a general overview, I intend to just run through a few ways in which RPs acquire land and some of the key points to consider when it comes to negotiating the development agreement. So the first one to consider is the golden brick arrangement. You can see that on the slide there. So the golden brick arrangement, it's sort of a method of structuring a land acquisition for residential property development in a way that essentially mitigates the VAT exposure of the parties. So it's a term used to describe the level of construction that a new development needs to reach in order to qualify for zero rating. So this arrangement, it allows housing associations to purchase land free of VAT, which might otherwise be charged. And this arrangement also allows the developer to recover its own VAT as well. So a clear definition of what is meant by the golden brick level is normally crucial to the success of the golden brick arrangement. HMRC states that the golden brick level is achieved when works are progressing above foundation level, so as to constitute a partly constructed building. In practice, though, the industry approach has been for the seller to construct the foundations and 1 metre of the walls above the damp course before golden brick is achieved. So when you're negotiating a golden brick arrangement specifically, I'd say that specific consideration needs to be given to the treatment of the deposit, the effect of golden brick on phased developments, mixed-use developments, or developments partly consisting of rental units and shared ownership units. And you'll also need to consider the interaction between golden brick and grant funding to be received by the RP. So some of the specific drafting points to consider within the agreement itself are, so firstly, you're acquiring the land at golden brick, so you want to ensure that adequate NHBC cover will be obtained and it will be put on risk prior to golden brick being certified. And there should be an obligation in the agreement confirming that evidence of discharge of all pre-commencement planning conditions and obligations are to be provided before golden brick can be certified. Okay, so next slide please, Sarah. Turnkey. Okay, so the next arrangement is a turnkey arrangement. And this is where the legal ownership of the land will be transferred to the RP or housing association when construction has been completed. And I suppose what I mean in this context by completed is it's reached practical completion and that's been certified. So the arrangement tends to be a lower risk arrangement as the land's sort of been purchased at PC. So the buyer, potentially could walk away from the purchase if the units are not satisfactorily completed. And of course, that does depend on the terms of the contract for sale or the development agreement. And just briefly, on a turnkey scheme, generally 10% will be paid at exchange, with the remaining sum being paid at PC. And the sale of the property to the RP will be considered the first grant of a major interest in the property, and therefore it automatically qualifies for zero rating for VAT purposes. Okay, so next is where the housing association, is that the next slide? Yep. So the next is where the housing association is acquiring the land with no set developer. And I suppose this tends to happen when the association is purchasing the land with the benefit of planning, or I suppose purchasing it conditional on the grant of planning consent. So generally here, we'd advise you on all elements of the acquisition on the land only, and you would then need to tender for development services, and generally that would usually be through a JCT contract drafted with an EA. However, we would be able to provide you with JCT guidance and I suppose any proposed amendments if you required this from us. Okay, so next slide, please. Okay, so when you are acquiring land under some of these arrangements, I suppose the build will also need to be considered, and these obligations tend to be set out in a development agreement. So I'm just going to really give you an overview of some of the standard provisions to consider when I suppose you are negotiating certain development agreements. So the first point to consider is the build standard. So when it comes to the build standard and the obligations around this, some of the factors to consider will be things like the construction needs to be in accordance with the planning permission and any requisite consents, I suppose. And in addition, we want any agreed plans and designs and specifications to be included and adhered to. We'll also want any works undertaken in accordance with the requirements of the NHBC warranty. And we'd want any work to be in a good and workmanlike manner and in accordance with any good practice. And finally, I just sort of mentioned you want to ensure that the material that will be used will be good quality and suitable. And sometimes clients, they'll have certain materials that they don't want used, and this can be sort of factored into the drafting as well. So really just in regard to the warranty, I should mention that you'd want the warranty registered before you've completed on the purchase of the land, and you should also check whether the warranty cover includes contractor's insolvency and an adequate year term. Also, you'd want to make sure that the warranty provider meets lender requirements using the mortgage lender's handbook. So I believe the handbook will list sort of the warranty providers that are going to be accepted, and this will be warranty providers such as NHBC, LABC and Premier Guarantee. Okay, so the next point is target dates and long stop dates. Okay, thanks. So target dates, they're usually set in relation to practical completion or golden brick milestones. So the target date can be extended if certain events occur, and normally they're known as delaying events. So for example, this could include adverse weather, industry-wide strike, shortage of labour, materials and force majeure events. And there will normally be provisions within the agreement to allow for extensions of time in these circumstances. So I suppose, again, depending on the arrangement, the purchase arrangement, LADs may apply, and that's liquidated damages. And essentially it's a pre-estimate of loss, which is paid to the association if the developer does not achieve PC by a certain date. And the assessment of LADs will include issues, such as loss of rent due to the units not being occupied, for example. But there will need to be a long stop date in the agreement, and that's essentially the ultimate date by when either PC and or GB will need to take place by, or that a buyer can terminate the agreement. Okay, so next we're going to look at payment provisions. So with regard to payment provisions on the build, the agreement should confirm the structure of payment and how these payments are going to be made. So the payment provisions will obviously reflect the type of development agreement in question, but generally they should specify whether VAT is to be included or excluded, set out interim or stage payments if required, and append or refer to an agreed schedule within the DA. So if we're looking at stage payments, then it may be that certain milestones need to be hit for a payment to be made, and this may need to be certified by your EA. So essentially, you'll want to specify what triggers the payment process and who certifies it. You'll also want to specify a mechanism, potentially, and procedure within the agreement for the RP to pay less where it considers this is necessary. You might want payment to be conditional on receipt of collateral warranties, the health and safety file and other documents. It might be prudent to specify a payment period, for example, payment within 14 or 21 days of the date it becomes due. And I think finally, where upgrades have been agreed, i.e., to the specification, the procedure for paying this should also be set out. Okay, so I'm just going to move on to the defects liability period. Okay, so the defects liability protocol, I'd say it always needs to be set up in the DA, and if there is one, and it will relate to a defects liability period which starts after PC and is for a set period of time. So suitable provisions in relation to a defects liability period and related procedures will normally be required within the DA. And this is just to ensure that any snagging items, whether arising immediately after PC, during inspection, or during an agreed period, so it's usually 12 months, but this could be anywhere between 6 and 24 months, are dealt with at the cost of the developer. So the provisions should also really include reference to the response times for defects that have been listed and should be categorized in the agreement. Generally, a certificate will need to be issued by the RP or its agent after the end of the defects liability period. And normally this will be done once the employer's agent or RP has undertaken an inspection of the building works, just to establish any defects or faults. So there should be an obligation on the seller to make good the defects in accordance with the defects protocol. And look, if the developer doesn't make good the defects, the contract should include a right for the retention to be used by the association to amend any defects. I'd also sort of say we might want to sort of see a GDPR clause in relation to the defects, and that essentially confirms that if access is required to a unit, for example, which is occupied by a tenant, the seller needs to enter into a confidentiality data protection agreement in order just to protect the personal data of any occupier. Okay, so on to practical completion. So within the development agreement, there will need to be a definition of what practical completion is in terms of, certifying PC. So from an RP's point of view, you'll always want the RP's EA to certify PC. So you'll want your EA to certify PC, as you would, you obviously want control over the process. So the development agreement should also document all of the relevant notice periods relating to practical completion, which will need to be provided to the RP in advance of PC. So provisions regarding PC will obviously need to be considered within the actual context of the particular scheme. But I suppose generally speaking, certain clauses should be included, and I'm just going to go through a few of them. So as I've mentioned already, a definition of PC needs to be included together with details regarding who's going to be certifying it and what the procedure is going to entail. There should be a provision for de-snagging inspections and a procedure for rectifying snagging items before handover. Handover notice period that is appropriate to the circumstances of both parties should also be included. So also, if stage payments are not required, you might want to consider what period between the issue of completion certificates and the final payment would be appropriate. So that's something to think about. You'll want appropriately detailed information required for handover as well, and that can include completion certificates, planning condition discharges, building control certificates, EPCs, health and safety documentation, and design documents. And finally, a schedule of information required at PC and handover, and that should be included in the agreement too. So I'm just going to move on to the next point. Thanks, Sarah. So the next point to consider is termination provisions. Why do we need express termination provisions? So generally, the development agreement should set out clearly the events that will give rise to a right to terminate, and a process that needs to be followed. So this is important because this will sort of remove any uncertainty that accompanies common law rights to terminate, and it allows termination for events that would not otherwise allow for automatic termination. So the contract should make provision for any necessary remedies if the contract is terminated. If the long stop date does pass and the RP exercises its right to terminate, there should be an obligation in the contract for the developer to return the deposit. Also, in the event of a termination, I'd say that the contract should also consider any ancillary rights to enable completion of the work. So, for example, if the RP already owns the land, the contract may include step-in rights for the RP to step in and complete the construction of the units. And in terms of IP, again, if the RP already owns the land, the RP might want to sort of be able to rely on plans and drawings. So there should be allowance for the RP to be able to rely on these documents by having, and what we do is just have sort of a copyright clause within the contract. Okay, so the next point is roads and sewers. So in the context of, I suppose, development agreements, we'll always need to consider if any roads or sewers are going to be constructed in the course of the development, and whether or not they'll be constructed to an adoptable standard. However, they may not always be adopted, and so potentially may remain private. So the responsibility to maintain them will need to be decided. So we'll always want to see obligations within the contract to construct them to a relevant standard and an adoptable standard prior to PC. And the obligation should always be on the developer to construct the sewers and all the roads. And we'll always want to see that they procure the adoption. So you might find that there are obligations in the development agreement for the RP to enter into an adoption agreement. And in this case, if that is in the agreement, we'll normally ask for the developer to pay the reasonable legal costs of the RP for entering into those associated agreements. And so there also needs to be clarity on who's going to maintain the sewers or roads. And I suppose that just needs to be confirmed. It could either be the developer or the ManCo, but again, it's something that does need to be confirmed. Okay, so just on to the next slide. Very quickly, there are a couple of standard indemnity provisions that we may request are included in the contract if they haven't been already. And so this might be in respect of SIL, planning permission, or the Section 106 agreement. Generally, we'll normally request that the developer indemnifies the RP against the breaches of the Section 106 agreement and or planning consent, and also sometimes in respect of non-payment of SIL. So if there is non-payment of SIL, we'd want to see an indemnity just to cover ourselves off in the contract. And I'm just going to make a sort of a final point. So if you just go to the next slide, Sarah. And I suppose the final provision I'm going to consider today is the just assignment clauses. So generally we'll want the RP to have rights to assign the contract if necessary in a DA. So the things to consider within the contract would be whether either party may assign the benefit of the agreement and to what third parties, i.e. A member of their group, and also how many times. And also on assignments, you may need to think about whether the agreement confirms that consents are required, and whether a deed of novation will be required prior to the assignment. And this is just to ensure that the assignee takes on the obligations too. Okay, so that was just a quick overview on some of the types of land acquisitions that you may have come across, and obviously some of the provisions that you might find in a development agreement. So I'm now just going to move on to the next topic for today's session, and that is buying land for development. So thank you, Sarah. Just wait for you to get the slides up. So if we just go to the first one, next one. Thank you. Okay. So yes, like I said, this part of the session, I'm going to focus on the title and just some of the main issues that you should consider when you're looking to buy land for development purposes. Okay, so the first slide. So when we're looking to undertake our title due diligence, the issues relating to title are set out in a report on title. I'm sure many of you have seen this document, and it essentially it forms a big part of your due diligence when acquiring land. And so there'll be various sections to the report, but I'll go through some of the main sections that will highlight and should highlight some of the pertinent issues. So the first section that we normally focus on is the property itself, the land itself. And so when you are purchasing the property, one of the main things to be clear on at the outset is the extent of the property that you're acquiring. So the property needs to be clearly defined and in accordance with the plans. And we'll of course review the information that we have against the title documents, but the plan of the property will need to be confirmed by you. And you'll need to be confident that it is the sort of the extent of the land that you believe is being acquired. It's worth noting that the Land Registry's General Boundaries Rule confirms that the title plan of the property indicates the general boundaries only, and so it's not the exact line of the boundaries. So you can't rely on the lines drawn always on the file plans as being the absolute and accurate representation of the boundaries of the land involved. So generally what we'd say is you should go and check the position of the boundary shown on any title or contract plans very carefully, and against obviously what you've seen on the ground when you visit the property. And always highlight if you think there's anything unusual about the boundaries of the land when you've been on your site visit, or any sort of boundary features. So the next important section is the executive summary. This section will set out all of the headline issues relating to the site that you're acquiring. It does help to set out the headline issues at the outset of the report, and every issue is set out here. If the issues are potential risks, then of course we would advise you of this sort of in the executive summary. And some of the examples include sort of out-of-date searches, adverse search results, Section 106 agreements, whether or not they need to be varied. Of course, that's something that we would highlight to you, and adverse rights and covenants. So that's sort of something that we tend to, and you should find within your report and title, sort of the headline issues, if you like. So the next part of the report will be outstanding issues. We always want to sort of ensure that any outstanding issues are resolved prior to exchange of completion. Early on in the transaction, we'll generally highlight any outstanding issues which should be brought to your attention. Some of these examples would include any significant matters not yet resolved. Are there any outstanding service charge budgets? Have you seen them yet? If you haven't, that's something that we are still waiting for. We'd pop that in there. Results of searches that we're waiting for, and potentially any policies that we're still waiting for. So normally we'll just sort of set out a section of things that we're still waiting for and potentially definitely will need prior to any acquisition. So the next point is on good and marketable title. So the report should always confirm that the title is good and marketable, which essentially means that the seller is able to deduce good title for the property, and the buyer is satisfied that the seller is in a good position to transfer the title to the buyer without the possibility of there being a dispute or litigation. So you want to see that confirmation in your report. I've just sort of added a little snippet of sort of what it would look like, or what it should look like. So yeah, that sort of gives you an overview of sort of the wording that should accompany or should be included within the report. Okay, so the next points I'm going to be looking at are development searches. So what I'll just be doing now is just running through our standard suite of development searches that we recommend when it comes to purchasing land. And I'll just sort of touch upon some additional searches that potentially might be required. So chancel, so just to give you a bit of an overview, the historic nature of chancel repairs means liabilities are often not recorded on the title deeds, but they remain legally enforceable. So we carry out a chancel check report to reveal whether a property is within a parish where a potential chancel repair liability exists. The law did change in 2013, and chancel repair liability is no longer an overriding interest. But you know, the risk hasn't altogether disappeared. So should the property have been disposed of since 2013, any chancel repair liability should have been registered against the title. But if no disposition for the value has taken place since 2013, we cannot confirm a notice has not or will not be served protecting the right to demand payment, which could later be registered against the title. So although the risk is low, you know, generally the cost of an indemnity policy is also low. So if there is a chancel risk, we would, in those circumstances, usually recommend a policy is obtained. Okay. Right, so environmental searches. An environmental search generally will always carry out, and it's a desktop search, and essentially it just reviews the historic uses of the property. It's sort of the standard environmental search should be split into sections. So you've got a section on contaminated land, flood risk, environmental hazards or constraints, and so it's a pretty comprehensive search. And it also should give you recommendations for further action and you know what you should be looking out for. So just on contaminated land, so the environmental search will give you details of past uses of land and the land in the vicinity of the property, and whether such past uses are likely to have been caused or have caused any potential contamination. So generally land contamination is associated with previous industrial commercial use on the site or on adjacent sites, you know, so all uses need to be sort of potentially flagged up as well. Under environmental legislation, if the land in the property is found to be contaminated and the person who caused the contamination can't be found, then the local authority can look to the landowner and or occupier to pay the cost of any remediation works that have to be carried out in respect to the property, but also in respect of the contamination which may have spread to any adjoining property. So, you know, obviously that, you know, the cost of those sort of works potentially could be quite high. So contaminated land is investigated generally through the planning process. And the majority of contaminated sites are cleaned up in this way during the sort of planning redevelopment process to make sure that the site is suitable for its intended use. So I suppose the way in which the development is structured, it'll determine who is deemed a responsible persons in the eye of the EPA. So for example, a contractor may take responsibility for any contaminated land on the site. An environmental consultant can be appointed to take on responsibility. The responsibility to deal with any potential contamination and remediation can be set out as the responsibility of the seller or the developer under the the development agreement. So yeah, I mean, and just finally, it is also possible to obtain an indemnity policy to cover any additional costs resulting from the need to mitigate risks on land, which is currently contaminated or discovered to be so during redevelopment. So the next search that we do is the local authority search. And this is sort of split into two parts. So you've got the local and charges, sorry, local land charges and the Con 29 replies. So local land charges is one of the most important things. One of the most important things that tends to sort of come up are financial charges, and these run with the land. So you will buy subject to any charges noted. So generally what we would do is we would raise inquiries with any potential seller to ensure that any outstanding payments are made in respect to these charges prior to any acquisition. The local land charges will also reveal whether the site is a listed building or in a conservation area. And if there is a TPO, you'll need to obtain a copy to determine whether any protected, so the search will potentially reveal any TPOs, and if there is a TPO, you'll need to obtain a copy to determine of that TPO to determine whether any protected trees fall within the boundaries of the site. So the location of these trees needs to be taken into account in the design process, and you can apply for a protection order to be lifted via the planning process. So depending on the type of deal, it might be worth raising this with, it's something we may raise with the seller if they are submitting the planning application. It's also worth noting that if the development is in a conservation area, then every tree within the zone is effectively covered by a TPO, and planning consent will need to be carried out if there is any work to be done on them. Section 106 is deeds of variations. They will all be noted and potentially need to be reviewed, and this is something that our planning team deals with regularly. Okay. And if the land is designated as common land or a town or village green, there'll be a restriction on its use and development. And this will, so if it is designated, it will show up. And if it is a serious issue for developers, it is a serious issue for developers if land is at risk of registration as a green or common. It is a common approach from neighbouring residential owners to any potential development site to apply to register land as common or village green to prevent developers being able to engage in any works on the site. Successful registration preventing development is also likely to devalue an area significantly. So it's important to look out for whether a claim could be made. You also have road proposals and environmental notices, any Article 4 directions. These will sort of also show up on the local land charges search. So Con 29 replies act as warning questions, giving information which may ultimately result in a local land charge. So planning and building regulation consents that have been granted, public highways and footways, road or rail schemes, statutory notices, any breach of building or planning control, environmental contamination, that's all sort of going to be listed there. And you can request any additional searches when submitting your local authority search, which I suppose may be useful based on the specifics of the site. Flood risk, it's an important one. The search will assess the risk from the main types of flooding, river, coastal, groundwater and surface flooding. So your flood search should tell you whether there are flood defences in place in the vicinity of the property. As you probably know, planning authorities will sort of take the risk of flooding into account when deciding whether or not to grant planning consent. And it may be that, flood protection measures are included within the conditions of permission. So we would usually highlight to you if there was a risk of flooding in the area. And of course, sort of our standard inquiry would be whether or not there's been any historic flooding at the property, just to sort of give you an idea of exactly whether or not there is a serious impact there. So the environmental search, so the environmental search will also let you know whether the property is affected by radon, and it may be that radon protective measures are necessary in the construction of the development. Environmental constraints may be identified, so these can include the site as being in the vicinity of an area of outstanding natural beauty and that sort of thing. And again, these sort of constraints will be taken into account by the local planning authority on consideration of the planning application, and the appropriate conditions may, at that point, be attached to the consent. And again, you know, if there are any environmental constraints, it's something that we would have to highlight to you at the outset. So just moving on to utility searches. Sarah, I think that's on the second slide. So sorry, the next slide. Yeah, thank you. Moving on to utility searches. So these reports provide sort of an initial overview of the main existing utilities, so including gas, oil pipelines, electricity cables, telecommunication wires, and other service media that are on the site. So, you know, if we're acting on like a package deal, for example, then we would raise these inquiries of the seller's lawyers as to whether or not, you know, the location of the service apparatus revealed has been taken into account in the design and build of the development, or whether they have entered into sort of any build over agreements. Generally, RPs will, you know, will rely on the building contractor, architect, and employs agents, surveyors for further advice with regard to the utilities, or sort of will enter into any appropriate build contracts that will afford them the protection. But of course, we do need to flag that up to you guys as well in our actual report. So if you're buying bare land to develop, then we would usually request that the utilities search is shown to the consultants, to your consultants, and services that are shown should be factored into the build. And you know, if you want to approach the utility providers to agree a diversion or the removal of apparatus, this, you know, potentially could be quite a lengthy, costly process. So if that is something that potentially may be required, then it's probably best to have those talks quite early on in the process to avoid any delays. So it's also worth noting that these searches only show public service media and not private service media, and that's generally going to be revealed by a detailed site survey and inspection. So yeah, you know, it's really important to always check what's on the ground, and then of course against what your search results reveal. Okay, highways. Moving on to the highway search. This is a full inquiry of the Highways Authority, and it reveals whether roads are publicly adopted, details of the extent of a public highway, details of highway proposals, schemes, and details of private roads. The highway search, it includes a plan showing the extent of the highway and the adopted road or roads in relation to the property. And I'd say it's particularly important to check that the public highway directly abuts the property. And if there is sort of a thin sliver, if there is a thin sliver of land potentially between the highway and the site, this could potentially be considered as a ransom strip, and you know, it can cause potential problems, and that's because, you know, you need to potentially pass over this ransom strip in order to gain access to the property, and you know, third parties who own these strips, or you know, ransom strips could demand considerable premiums to allow access to, you know, your site. So it's important these are found out before the land is purchased, so that, you know, you can, so that the buyer essentially can demand that the required sum to release the land should be deducted from, you know, potentially either the purchase price, or you know, you might want to pull out of the deal altogether if an agreement can't be reached. So in addition, if access to the site is required over third-party land, you might need to consider obtaining an insurance policy, or potentially negotiating a right-of-way with the person who owns the land between your plot and the highway. It's also important to make sure that you've got sufficient rights over state roads. If we're just acquiring plots on the development site, which do not themselves abut the public highway. And if there is a private road which falls within the boundary of the site, then as the buyer, you need to make further inquiries into who has the benefit of the private road and who's using the private road. And if the owner of an adjoining property, has used a private footpath or a road continuously for over 20 years, then there is an argument that they may have been granted a right of access over the land through prescription. And in those situations, people may need to be approached to negotiate an alternative right of way, or the private access needs to be factored into any proposed development. So if a public right of way exists, as a buyer, you need to, we'll be making the inquiries on your behalf to the seller to ensure that that's been factored into the design, or diverted or stopped up, and that often can sort of be in tandem with a planning consent requirement. Okay, so just very briefly on additional searches. So that's just on the next slide, Sarah. Thank you. So additional searches include coal mining searches. They may be commissioned if the land you're looking to buy is likely to be affected because it was in a former coal mining area, and there may be a risk of subsidence. A planning search can be commissioned, and that generally will reveal information about proposed development and land use designations in the area. And you may be a necessity to take out or commission even an energy and infrastructure search, which tends to reveal any potential energy and infrastructure projects in the area. And so that can include projects such as High Speed 2, Crossrail, fracking, and any other sort of renewable power plants in the area. Okay, so that was an overview, if you like, of sort of your standard suite of development searches, and sort of what the impact that they can have on a proposed purchase. So I'm just going to run through some title issues that you might come across when you're purchasing land as well. So thank you, Sarah. So for example, if you're acquiring land, one of the first things that you want to do is check whether the seller is actually, the registered proprietor or the owner of the land. 9 times out of 10, the seller will be the registered proprietor, and of course the interest should be registered at land registry. If, however, whole or part of the property is unregistered, then of course further investigations need to be carried out. And so, if there is unregistered land involved, title will need to be deduced to us prior to any purchase in the usual way. And as the land is unregistered, it's paper title deeds which will prove ownership, and they'll be required in order to check the seller's title and prove title to the buyer. And sort of an epitome of title will then need to be prepared, and that tends to consist of schedule of all the documents of title, along with photocopies of the documents themselves, assembled sort of for deducing the title to unregistered land to prove the seller's ownership. So it can be quite a drawn-out process to verify ownership of unregistered land, and then obviously to subsequently purchase it. Okay, restrictive covenants. Righty. So I suppose the next point to consider is restrictive covenants and how they are dealt with in the context of land acquisitions. So essentially, a restrictive covenant creates a restriction on the title to the property that is intended to prevent a buyer from using or developing the land in a particular way or a certain way. And so the restriction may continue to bind successors in title, and the benefit may belong to a defined people or groups of people, or to owners of the benefiting land. Generally speaking, you'll want to know who has the ability to enforce the restrictive covenant, who's the beneficiary, what exactly is being restricted, and finally, do they even affect the property that you're purchasing? So examples of restrictive covenants would be restrictions such as not to do anything that may damage the electrical lines, not to construct any structure within 1.5 meters of an easement strip, not to undertake or permit to be undertaken any development upon amenity land, not to use a property as a public house or a place for the sale of intoxicating liquors or a club. So the main thing to consider, though, is the impact that these will have on the development of the property. So considering the risk is, really important. So for example, on some Section 106 acquisitions, you'll find that the developers will have taken some restrictive covenants that are affecting the title into account in their development proposals. So in that sense, there is no risk of the restrictive covenant that does affect the land to, being breached. So during our title due diligence process, we will normally ask whether the development proposals have factored in, these potential restrictive covenants. Sorry, can I just ask that everyone puts their mics on mute, please? Thank you. Okay, so the next point is if it is clear that there is a risk the restrictive covenant will be breached, then in potential situations we could suggest that an indemnity policy is put in place. But this also depends on the circumstances. So it should be. I think the main thing to note, though, even if we were to potentially take out or advise that an indemnity policy, can be taken out, the indemnity policy is not going to stop the beneficiary from enforcing the covenant. So there's always that risk. But I suppose what it does do is provide protection against financial losses that might arise in the event of an enforcement or an attempt in enforcement of a possible breach of the restrictive covenant. So similarly with unknown rights, there may be a situation where the title refers to unknown rights affecting the land, but we don't know what they are. In this situation, generally, we may ask the seller to see if they actually do hold a copy. And if not, depending on the circumstances, a policy may need to be put in place in case, the beneficiary of those unknown rights exercises these rights over the property. So just on to the next slide. Thank you. So I'm just going to have a quick, I'm just going to talk briefly about existing easements. So very generally put, an easement is a right over another person's land. And these rights come in various forms. And some examples would include, a pedestrian and vehicular right of way, right to enter onto the property for the purposes of maintenance of adjoining land, rights in favour of utility providers. So you'll want to know what easements benefit the land, but also that you're purchasing, but also whether there are any easements granted over the property that could be problematic. So for example, there may be a right of way of the land that you're purchasing, and we need to consider the impact that that particular right had on the units of the land that you're acquiring, and also whether it impeded on the right to use the property for its intended purpose. So just moving on to prescriptive easements. I did briefly touch on this during the development searches section, but in a nutshell, these are rights over another's property which are gained through long usage. So just quickly, an easement may be acquired by prescription where the owner or the occupier of the dominant land has used the servient land in a manner that is capable of existing as an easement. The use has been as of right, that is without force, without secrecy, and without permission. At the time of the presumed grant, there was a competent grantor and a competent grantee. And if there had been an express grant, the grant would have been lawful. And finally, if there is no obvious explanation for the use other than presumed grants. So I won't go into the details of the law too heavily, but the three main ways of establishing prescriptive use are either through common law under the Prescription Act 1832 or by the doctrine of lost modern grants. And the main point to be clear on with prescriptive easements is that in order for it to be a prescriptive easement, it will need to have been used for 20 years, will be as of right, and is being used continuously. Okay, next slide, positive covenants. So I'm just going to have a sort of a brief overview of positive covenants. And essentially, they do differ from restrictive covenants, as they don't generally run with the land, and they're normally worded in a way which requires you to do some sort of positive action, such as building a fence. And so, in order for them to be enforceable, the original party to the positive covenant is bound by these covenants, and generally, like I said, in order for them to be enforceable, there will need to be sort of a chain of indemnity or a compulsory renewed covenant, and that tends to be protected by way of a restriction on the title, and those would be required in order for the burden of the positive covenant to pass on to the new owner. In terms of charges, if there are any charges and restrictions and notices affecting the land, we'll always want these removed prior to the buyer purchasing the land. We would normally insert an obligation from the seller to provide these discharges, and coupled with sort of obtaining an undertaking from the seller's lawyers to say that all the necessary releases will be provided to us prior to the acquisition of the land, because you don't want to be taking subject to them. Electricity substations. So you might find that there are electricity substations that are situated on a development site, and the main thing here is to check whether the substation has any rights that are granted so if there are any rights that are granted in respect to the electricity substation, and they don't affect the land that you're acquiring. The title may have a registered easement in respect to the substation, so this is something we will normally go through, and just to make sure it doesn't affect the property that you're acquiring. Generally, if there is that sort of setup, you can't build around the cable easements, and you tend to sometimes be restricted from any digging, things like that. So yeah, that any electricity substations, if you've got it within a development site, I suppose you want to be making sure that it's been factored in. Okay, and finally, so this is just my final slide. So when you are looking to identify an issue, there'll of course be some key points to consider. So firstly, does the issue to hand even pose a risk to your purchase? And if so, how costly is this risk? So if we are considering covenants, for example, you may need to look into whether the adjoining landowner still has the benefit of a restrictive covenant, for example. And I say this because in order for a covenant to be enforceable between the successors entitled to the original parties, the covenant must still benefit the land owned by the person that's seeking to actually enforce it. So, that means the covenant is must touch and concern the land owned by the person that's enforcing the covenant. You might want to consider, when you are posed with a risk, you want to consider whether the risk is still subsisting, and if so, can we get a release from it? Again, in relation to covenants, if you've got a restricting covenant, is it still enforceable? And could you negotiate with the property owner who has the benefit of it to enter into a deed of release potentially? So that's something to consider. Alternatively, with risks, again, in the context of a restricted covenant or a covenant affecting the land or the land that you're acquiring, can you obtain an indemnity policy? And I suppose even when you are looking at obtaining an insurance policy, things to look at in that instance is, can you even get a policy? So, some of you may know, approaching anyone who might have the benefit of a covenant can, invalidate an existing indemnity insurance policy or prevent a new insurance being put in place. So I suppose that's an example of where a policy, might be difficult to obtain. And I suppose, you know, if insurance isn't available, then it's for you to decide whether or not, you know, it's still worth proceeding without the insurance based on the evaluation of the risk. And finally, you know, if you are able to get a policy and you're happy to proceed with it, you know, you might want to check that insurance is available at acceptable rates, and potentially if the seller is agreeable to pay for the policy. Okay, so that's my overview of title issues that affect land acquisitions. I hope that was helpful. I'm now going to pass you over to my wonderful colleague, Sarah Wheeler. Thank you.
I'm on mute, sorry, the usual saying. I'm just going to do a quick whistle-stop tour then on land registry registration. I literally only spent a couple of minutes on this just to tell you exactly what we do, and then I'm going to move on to site setup, so where it goes from Jyoti's team down to the new build team. So obviously from your development team to your sales team. So let me just quickly share my screen again. Perfect. And apologies for the dog. Joys of working from home. So land registry registration then. So what we do is firstly we obtain the transfer or the lease, whatever you've taken on acquisition, from the other sides, and it is submitted to the land registry. But there are a few hurdles we need to go through before this is done. So the second thing is that we obtain an SDLT from yourselves. So you're all probably very familiar with these forms. Essentially, obviously, it's a stamp duty land tax. I won't go too much into the details. That's another training session if you'd like it, on different reliefs available. But we normally prepare these and send them to you prior to completion in any event. But on completion, after completion, they are submitted to HMRC with the effective date being the completion date put in. Once that's done, obviously we have to ensure this is done within 14 days of completion to ensure that no penalties are incurred. When the SDLT has been submitted, you receive a SDLT 5 certificate from HMRC, and basically all that says is you've paid your stamp duty, we're happy. But that is what the land registry want to see when we submit it. So once we have all of the documents through from the other side, from seller solicitor, the SDLT 5 and any other certificates we may need or discharges, we can submit the application to the land registry. Now we do this within the priority period. So before completion, we have a search that is put in at the land registry called an OS2, and that's just registering your priority in priority order for your transfer to go in, to make sure nothing else is going to be put in between exchange and completion. Once that's submitted to the land registry, as you know, the land registry are not the quickest. Sometimes it could be quick, sometimes it could be months and months before they register it. So it's fine. We don't worry too much. But if we get any requisitions through from the land registry, they could be questions on the transfer, any incomplete information, which there shouldn't be, because they should be all pretty fine. But if there isn't, and there are requisitions raised, then we do respond to them within the time frame set by the land registry. Once they're dealt with, if any, then the title is registered. So we get notified of the title registration, and what we then tend to do as good practice is double check your title, double check that everything is pulled through correctly as we would want it to, make sure there's no unusual restrictions pulling through, as Jyoti said earlier, make sure there's no notices or anything odd that shouldn't pull through, and everything is correct. And once it's good to go, we send it to you guys. So there's not too much you need to know about registration, because obviously that's what we are for. But it is always good to have a little bit of background just so you understand the process. So now I am just going to move on to the new build site setups. So let me share my screen. Perfect. So my name is Sarah and I am a trainee solicitor in the housing development team. My background at Capsticks is that I started off in the new build plot sales team and home ownership. So I dealt with the sales teams, selling the plot sales and assisting with site setups, which is where we collate the documents in order to sell on what has been acquired by Jyoti's team. So what we need and to prepare this setup. I think it's a good thing for development teams to have as an overview of what your sales team require. And it's also good to have the communication between each other to ensure that people aren't coming back to you for further documents later on down the line when you go to sell the properties. So these are just a few of the items that we require when we set up a site. Obviously, I will take them all in turn, so I'm not going to run through them now, but we have the report and title, replies to CPCs, any title documents, plans, indemnities, Section 106 and any subsequent deed of variations, any sectional agreements, searches, development agreement, planning permission, handover dates, home warranty, PEA or the EPC if available, and a lease questionnaire. So, when will the information be available? This will depend on the stage of acquisition. Pre-contract, we should have the Section 106 agreement, the planning, developer's title, or other title document searches, and usually an agreed estate transfer. Obviously, if it is a contract subject to planning and it's not there yet, then obviously we may not have that just yet, but it's just a sort of an indicator roughly on what we would have. Post-contract, we should have all other documents. It doesn't matter when we are instructed on the site setup. The rule of thumb for most clients is they like to be to instruct their sales solicitors 6 months prior to handover, or 6 months prior to marketing, just to give enough time to collate all the documents and have everything set up and prepared. But we have taken some setups years in advance, just because they've been ready, and why not be ahead of the game? So, title documents. We want to see, obviously, your title, your register and your plan. If it isn't available because you haven't entered into the transfer yet, that is absolutely fine, because we can decipher from the developer's title and also the estate transfer as to what is going to appear on your title. So we can easily set up our information for the buyers based on that without having the title registered. I've just mentioned on there as well about indemnity policies. So sometimes, like Jyoti said, there will be indemnity policies. And if, for example, there is some missing particulars or some unknown covenants on the title, then we obviously want that as well, just to put into our site title section for the buyers. I've also put on there confirmation of a U and 4, and this is basically because a lot of the time there is a unilateral notice on the developer's title in favour of the development agreement and in favour of our client, so the buyer. This sometimes doesn't get taken off. So we want the acquisition solicitor, which if it's in-house, it's easier, to confirm that they will submit it and take it off so it won't pull through to your title, and also to confirm, if not, and it is to pull through, that we can then remove it when we sell to the buyers. And this is just a very common inquiry we get from buyer solicitors, because no one wants a unilateral notice on their individual leasehold title. So it's a good thing to just have that prepped in advance. Planning. So we would like then the outline planning permission. The reserve matters if it's available at the time. And planning tracker. Now the planning tracker is very important for pre-commencement and pre-occupation conditions. Lenders and buyer solicitors will require this. And sometimes the planning portal are not as quick, the planning authority aren't as quick as uploading their discharges to the portal. So having the planning tracker to show buyers is very useful, rather than sending individual discharges. Section 106 agreement and any deeds of variation, if applicable. Also, I will mention the deeds of variation. If you are currently in draft for a deed of variation, we're quite happy to receive the draft so we can advise as well on what is going to be amended. Again, it just gets us ahead of the game. So the Section 106 agreement I've just put up, these are a couple of the points that is looked at. I'm not going to go into detail because that's for our planning team. So our planning team will review all the different parts of the Section 106 to make sure they're compliant with your instructions. And this will then already be taken into account when we do the site setup. So this information that's on the slide is what we can then reiterate to the buyers to say for any questions. Because we do normally get questions about whether lenders are going to be bound, and it's very much in their CML handbook. So it's quite common questions we'd like to squash at the outset. Designated protected areas then. This is obviously quite a common one for some people and some places. I'm sure you'll all be aware that this DPA search is carried out on acquisition, and essentially basically if the properties are grant funded and they fall within a designated protected area, the shared ownership lease must comply with Schedule 4A of the Leasehold Reform Act 1967. And in a sense, this is just saying that the property is to be limited to an 80% share, and you can't staircase beyond that, or if you do staircase beyond that, then it will be subject to a mandatory buyback to the landlord or the nominee. Now, a lot of the time clients obtain waivers from Homes England, and that's fine, but we just need to know from the outset if you've got that waiver so we can pop it in the file, because again, this comes up for lenders and buyers obviously ask these questions. If you don't have a waiver, that's fine, but we need to know the structure of how you'd like to proceed with your leases. So if you would prefer the mandatory buyback provisions, or if you'd like to restrict them at 80%. The estate transfer then. So whether it's completed or not, if it's completed, it's brilliant, we can pop it in the file. And if it's not completed, there will usually be an agreed form in the development agreement or next to it. So this is quite key for us, obviously, especially if client has not taken the title yet. So we can then decipher from the developer's title and the agreed form of transfer what is going to appear on your title, and then in sense what's then going to appear on the buyer's title. So it's all sort of a chain of events here. So the agreed form or completed transfer is obviously required to prove we can sell the property. We like transfer plans, especially if the transfers haven't been taken. It's good to identify the cluster of units that will be taken in each phase, if you are doing it on a phase-by-phase basis. The estate transfer will also reveal restrictions. So I will talk about restrictions in a minute, what we commonly expect for shared ownership. But it will tell you what restrictions are going to appear on the your title. We also see any obligations sometimes with estate roads and sewers, but this will be very dependent on the seller's sort of agreed standard form of transfer. If there's a management company, we have management company obligations, and then there'll be the usual covenants, rights, reservations, and any estate charges that need to be considered. The development agreement. So we require this for information purposes. The development agreement will, like I said, have the draft transfer annexed. It will also set out the obligations relating to any sectional agreements, compliance with planning and requisite consents, and just the seller and buyer's obligations. It will also contain specifications of the property, for example, the accommodation schedule, which is also very important for us to note what plots are coming through, postal addresses, etc. But this is normally sent through separately in any event. It is key to remind, though, that the development agreement is confidential, and we don't usually advise that this is disclosed to buyers, because all the information is contained in the other documents. This is just for our information purposes to get a full understanding of the site. Now, restrictions on title. So we have the restrictions that appear on in the transfer, sorry, or the lease, whatever way you're obtaining the property. These will then appear on your title. And in order to grant shared ownership leases or sell them on as outright open market units, we need to comply with those restrictions. So you need to think ahead in the development team as to what are our sales team looking to do. Are they looking to sell these as shared ownership? Are they looking to sell them outright? And do they want to be caught by this restriction? So the common, among other ones, the common sort of phrased restrictions are no transfer or no disposition without compliance with something or another. So no transfer is fab for a shared ownership lease, because shared ownership lease is a lease, so you don't need to transfer it. So automatically we will not be complying with that restriction, and compliance is not required. If it is no disposition, then the lease, if shared ownership lease, will be required to comply. So I think the key thing here is to think about the disposition. So think about the nature of the restriction when you're advised on acquisition, and just bear it in mind. Usually, for example, some of these restrictions could be in relation to confirming that obligations will be carried out, like paying an estate charge, or that buyer will enter into a deed of covenant. And really, shared ownership leases don't necessarily need that, because you are the landlord. So it's not something that's necessarily needed into 100% staircasing. So it's just think about that when you're wording it, because you don't want the buyers to crop up with unnecessary costs of certificates of compliance and deeds of covenant in the future if they can avoid it. So we can also, in the restrictions, you can specifically exclude a shared ownership lease. So you can put no disposition except for a shared ownership lease. That is fine, but that's just not in standard form. So the Land Registry just charge extra to put that on the title. Certificates of compliance then. If any certificates in relation to restrictions, we, from a shared ownership and new build sales point of view, like to see a conveyancer can certify it if possible, because that means that the obligation can be passed on to the future buyers and no one has to worry about providing certificates. They can all certify it themselves. However, if there is a management company required to give consent, or the council, you need to consider this just to make sure who needs to sign it, contact, if there is any requirements they need. Do they need a copy of the lease on completion, which we can find out for you, but they're just some considerations. And also, especially if there's any fee involved. It's affordable housing, and I know clients don't like to provide unnecessary costs if they can avoid it. So that's just another thing. Some councils and management companies will charge for a certificate. So again, it is just bearing that in mind when you are looking at restrictions with your acquisition solicitor. Site plans and plot plans. I'm sure they are the bane of a lot of people's lives, but they are very helpful to us as well. So we have on-site setup. We can do plan approval for you. And when I say do, we send it to Land Registry for plan approval. Now, you don't need to do plan approval. It's not necessary, but some people prefer to do it. The Land Registry Guidance PG40 sets out the provisions for what a good plan looks like, and it would include the north point, clear surrounding areas, detailed edging of the property, among other things. But it is important to note that the Land Registry will not give plan approval for any units that are under 5, that are 5 units or under in a scheme, and also they won't do it until your title is registered. So sometimes it's just not feasible to have it done in time. Site plans. So the site plan should clearly show the plots being transferred. And if there is a management company, we want to make sure that we can see sort of the areas that are needed. And this should be reciprocated in the plot plans. This again avoids ambiguity and any confusion with the plot plans going forward, and also makes it easily identifiable in the leases as to what parts of the property is being conveyed. I will just note as well that on plot plans, we mean the individual conveyance plans, and when there are flats or fogs, we do need to see floor plans as well, because the Land Registry will need that in order to, again, we put that in our leases, and to be clear on what is actually being conveyed, because you don't want to accidentally convey a whole property if it's just a flat. We normally in the development agreement, there is or will be a provision that the seller will provide the plans, but again, it will depend on the structure of the development agreement. When is best to have plans? Now, we get asked this question quite a lot, and the short answer is ASAP. as soon as you can, really. The good thing is that we will happily review the individual conveyancing plans for you in the new build team to make sure that they will be compliant with any leases, and then we can send them back and you can amend them if necessary, and they can be ready in time for reservation. We can still send the contract pack out without the plans, so you can still take reservations without them. It's not a problem, but that may cause a delay in that we can't finish the drafting of the leases without these, and also solicitors can't order searches. So that's just something to bear in mind if you're looking for a speedy turnaround. Warranty provider, obviously we want the cover no. Final certificates will be available obviously once you've taken handover, but as long as we have a cover note, then lenders and buyer solicitors are happy with this. I've just put in there activation. So activation with regards to an HBC, for example. So it will depend on the client's stance, but quite usually, if it is a shared ownership property, the landlord, as yourselves, will activate the NHBC policy and provide us with the final certificates, because you are a landlord and you're retaining an interest in the property. If, however, it's an open market sale, this obligation normally gets passed on to the buyers and their solicitors to activate their new policy. So it's just to be clear on what you'll be providing, so that the buyers know that if they're going to get final certificates or if they need to activate them themselves. So that's just something to bear in mind. Roads and sewers. So Jyoti covered this earlier, but I'll just quickly run through in respect of sort of new builds. So we like to have your highway search and your drainage search for information only. This just helps us relay any sort of inquiries to the buyers if need be. We like to have any sectional agreements if you've got them, so section 38, 104s, 278 agreements, but we understand that they're not always available at the outset. If they're not available, then we like to have the technical approval and all the plans. So you should have them way before the sectional agreement's drafted, but this is just helpful for buyers lenders, so they can see the property being conveyed, because as part of their CML handbook, they need to see, the roads being to be adopted and not to be adopted. Obviously, if they're not going to be adopted, the roads or sewers, and they're going to be privately maintained, then we just need to know about that. So again, we can reiterate that to the buyers and make reference, provide the necessary rights of way over the roads, for example, in the leases. And then we've got some miscellaneous. So we like to have the report on title, which is your nice big book that you get sent across from your acquisition team, and the replies to CPSE. Now, these two are literally for our information purposes only. We do not disclose them to the buyers. Again, they're just to give us a full understanding of the site, which is very helpful, especially if we haven't worked on acquisition. We also like to know PC handover dates. Now, I'm sure everyone knows that these are subject to change, and that's absolutely fine, but predicted is always good, just so that we can put the projected dates into our information and collate that for the buyers. Any handover documents, if they're available. If you haven't taken handover yet, then obviously that's fine. But what we do say is, when you do take handover, if you ping them over to your sales team or to your marketing team, whoever deal with the new build sales directly, then we can just add them to the file as and when, even if there's no reservations. It means that we're not coming to chase you later on down the line for documents when we're looking to exchange and complete. So it will help everyone in the long run. Also, any management company. So if there's going to be a management company to be set up, we obviously want to know about this. We'll obtain the articles of association and the memorandum, certificate of incorporation, just for information for the buyers. Service charge budget, so that's obviously very important, especially for shared ownership units, to know what's being contributed. And also, if there's a management company, then we want the management company budget as well. So if there's estate services, we do need both of those. And then finally, I've just put on their lease questionnaire. Now, this is something that Capsticks send across at the outset to your sales and marketing team. So when we get instructed on site setup, we send out a lease questionnaire. And now the lease questionnaire just covers sort of some ad hoc items that will not necessarily be in the documents. For example, is there going to be solar panels? Are you aware of any overriding interests? Is property grant funded? So it's just a very quick reference guide that's normally sent over to you guys to go through to fill out and send across, or the sales team will do it wherever your setup is in-house, and this just provides the basis for our site setup, of the information we can pull and put in the contract pack for the buyers. So it's just a good quick reference guide, and we also have on there any contact details. So if there's any who we should be contacting in your development team and your sales team, who your acquisition solicitor is, even if you've got a planning matter going on. So it's good to have everyone in one place so everyone's not chasing different people on different email chains. At least we can go to there for a quick reference guide. It is very good to have, a lot of clients do prefer to have your acquisition and your sales within the same firm for one scheme, just for a smoother transaction. And obviously a lot of this information, when it's in-house at Capsticks, we can ascertain it ourselves. Just a quick rundown of the contract pack. So the contract pack to the buyers will be the contract pack in the standard form, amended to the scheme. Then we've got the information sheet, and this will be sort of the collated document of what the buyers need to know going forward, and it will take all parts of your acquisition, we pull it apart and we put it together for the buyers. So we literally take everything that's been put together by our acquisition solicitor, we pick it all apart and put it together for what the buyers need to know, and that's all contained in our information sheet. We have the shared ownership lease or open market transfer, again on the particulars of the scheme, but also in the client standard form. A schedule of documents regarding which tells us how many documents are going to be provided and what documents are going to be provided. So if we miss any, we can just highlight to follow and we can wait for them from you. And then finally, just deed of covenant. Sometimes, like I said earlier, if it's required, that will be in there. Searches. So we like to have your acquisition searches for information purposes, and any site searches you'd like us to conduct, which is normally a question for your sales team, that is also possible. So what we do is we would get site-wide searches and then just charge a percentage back to the buyers to pay for the cost. So it's cheaper for all parties and does help smooth the transaction along. Speaking of making the transaction smoother, so this is the key things, communication between buyer, acquisition and sales team, and that's just the availability of the documents, any panel solicitor. We send through dummy packs to the panel solicitors and sort inquiries out pre-reservation if possible, and also searches. So like I said, site-wide searches are also very helpful if that's the route you want to go down to make it smoother. I've just left up a slide here just to make you guys aware of any current issues and topics that currently are facing the site setups and obviously development. So we've got the need for EWS1, which is holding up some sales and some marketing. I've just put a link there. That's one of our, this is the title of a insight that we have produced recently. And again, on the leasehold reforms, there's another insight there. And just to make you aware that on Capsticks' website, we have an insights page and we regularly publish articles about current topics. And these two are quite prominent in the sector at the moment, and we've had some webinars on them. So just wanted to make them available for you. I believe just in the nick of time, we have, if anyone's got any questions. If you don't, then that's fine. But if anyone has any questions for either myself or Jyoti, please do.
We've just had something in from, apologies if I'm not pronouncing the name correctly. Is it Gavak? Don't know if you can hear me. No. Okay, so I've got a question come in from Gavak, and they've kindly asked if you could sort of give an example of when a deal hasn't gone through, perhaps something alarming came back from searches, and you know, how was that dealt with. And I think it sort of goes back to what I was saying in terms of risk. I mean, obviously, each deal has its nuances, but you know, there will always be issues on each deal that can be resolved. I personally haven't had a deal where it hasn't actually gone through, but recently I was working on a matter. It was an acquisition of turnkey units, and between the land, the RP's land, and the development site, you had a sort of a watercourse, which wasn't actually a watercourse, but it was sort of a, it was essentially, it was a watercourse. It was a strip of land, and in order for any services to go through to the units, it would have to have gone through the this strip of land. So I think it was just at that point, you know, just putting the risks to the client and just sort of saying, you know, we've got a strip of land. It basically acts like a moat around your land, and you know, how do you want to deal with it? Would you like to proceed? And I think in that instance, they were happy to sort of obtain a policy, so that they, you know, of course, because essentially that strip of land would have acted as an access way. All the services would have gone through it, and they were happy to just sort of to go ahead with a policy. So that's probably one of the most very recent examples I can actually just think of on the top of my head. It's a very small example, but I think it, like I said, it just comes down to the particular deal. And so yeah, that's my sort of experience at the moment. I don't know if any of my colleagues have got anything that's a bit more juicier that they can remember and they want to mention.
I think you're calling on me there, Jotty, I think, are you? Yeah, well, I'd probably, hi everybody, I'm James, I'm a partner here at Capsticks. Yeah, I've got a few more experiences, but I think I think the question was regards to searches. I've never seen a deal go sour because of searches. You do sometimes get things that are thrown up, and it's usually pipes, sewers, or cables. So one of the biggest ones that I thankfully didn't have to deal with was a site down in Hampshire where there was I think the largest gas main in Hampshire ran through the middle of the site, and for some reason it wasn't flagged up on the searches. Everything has a financial cost, so it's all down to, once you find out what these issues are, how much is it going to cost you guys to put it right, and whether you've got enough flesh in the deal to actually pay for that. Back to you, Jyoti.
Thanks. So yeah, I think that's just sort of an example, a few examples of what we've had. I don't know if there's any other questions, and you know, please do feel free to pop if you can't think of anything at the moment, or if something comes to mind after the session. Myself, Sarah, James, more than happy to sort of take any questions and sort of just run them through with you.
Thanks, Jyoti. So yeah, thank you all for joining, and like Jyoti said, if you've got any questions, please do let us know, and enjoy the rest of your day.
Thank you all for attending. Thank you.
Thank you.
Thanks, guys. Thank you.
Thanks.
Thank you. Thanks. Bye.